Good morning. I'm Damian Falkowski, and with my colleague at 39 Essex Chambers, David Sawtell, we will be presenting a webinar to you this morning, Break Clauses in a Time of Uncertainty.
What we're talking about today is break notices, first of all. Is it the right key, which alone is capable of turning the lock? So we're looking at issues of contractual interpretation, both of the notice and the clause itself, and issues as to service and time when it comes to actually serving break notice. We'll then go on to consider conditional break clauses and whether they are snares for the unwary, which feeds into the next point, which is how vacant does vacant possession have to be? Because quite often a break clause requires a tenant to surrender up the premises with vacant possession. And of course, if a landlord wants to hold on to a tenant, they will seek to argue that in fact vacant possession was not given. I'll then go on to consider how the Landlord and Tenant Act 1954 affects break clauses if you have a tenancy that is protected by the 54 Act. Then finally, we'll consider the interaction between break clauses and land registration. So the right key, which alone is capable of turning the lock, is a quote from Lord Gough's speech in Mannai Investment Company Ltd against EGLR Life. And that was, in fact, a dissenting speech in this case. He opposed the majority of the House Lords holding that the tenants simply had failed to activate the break clause using a break notice, which on its face had given the wrong date. In his words, simple fact is the tenant has failed to use the right key, which alone is capable of turning the lock. One of the issues that comes up with break clauses is the need for strict compliance with their terms. But how strict is strict? Because a break clause gives a party the right to end the tenancy before it's otherwise due to expire. And the courts are being consistent in holding they are a form or a species of option. And as with other forms of option agreements, strict compliance with their terms are required. Break notices are seen as technical documents because they don't require the consent of the other party. You are trying to end the tenancy early. The other side may or may not agree with that. And being unilateral instruments, they are in many ways seen to be, should be interpreted in a slightly different way. But there has been a disagreement about what is meant by strict compliance. When we look at the old law, often we're directed back to the case of Hankey and Clevering, where Master of Rolls, Lord Green, said this: notices of this kind are documents of technical nature, technical because they are not consensual documents, but if are in a proper form, they have of their own force without any assent by recipient, the effect of bringing the demise to an end. So on the face of that case, if a break notice contains inaccuracies, even if it's clear on its face what was meant and what the sender wished to do, then a miss was as good as a mile, which didn't seem to fit the way that modern commercial documents are now read. The other side of strict compliance is expounded by the case of Reed Personnel Services against American Express Limited. And Mr. Justice Jacobs said that where a lease contains an option which may be exercised only upon fulfillment of a condition, it is essential that that condition, the so-called precondition, be fulfilled before any purported exercise of the option can be valid. So on the one side, we have, do break notices need to be absolutely clear on their face, and if there's a mistake, then they fall away, which seems to be a more old-fashioned way of looking at things. On the other side, in terms of strict compliance, we have cases such as Reed Personnel Services, which do tie in more with the idea that you need to comply with requirements strictly, but otherwise you need to construe the documents applying a modern rules of contractual interpretation. And these points came to the House of Lords in the now very famous case of Mannai Investment Company Ltd against EGLR Life Assurance Company Ltd. In that case, Hankey and Clevering was doubted. It was held that the construction of the notices had to be approached objectively. The question was how a reasonable recipient would have understood them. and the notice itself should be construed against a background of the terms of the lease. So, although you still had to comply with the clause itself strictly, the break notice had to be read against a background factual matrix, as you would expect with a normal commercial document. I'm going to hand over to Damian, though, to consider just one of the comments that came up from Lord Hoffman.
Well, the law should be about achieving what people would regard as common sense. And so Lord Hoffman used a number of analogies, and here is one. If someone has gone to great pains, well in advance, to secure tickets for himself and a friend for a Beethoven concert at the Royal Festival Hall by a famous visiting orchestra on 13th January, and says to the friend a week earlier, "I'll see you at the Festival Hall concert on 12th of January, it'll be obvious that he is referring to the concert on the 13th of January. According to the old rules of construction, the law will agree if there is no concert at the Festival Hall on 12th January. In that case, there is a latent ambiguity. But if there is a concert on that date, Stockhausen, say, played by a different orchestra, he will be taken to have referred to that concert." Now, with great respect to Lord Hoffman, and I have read this passage over and over again, I come to the contrary view on that analogy that he has used. I could be very wrong, but I wonder, viewers, listeners, if you read that, what conclusion you would come to. Let's look at the facts in Mannai. There were 2 leases, 10 years from 13th January 1992, and this is what the clause said. The tenant may, by serving not less than 6 months' notice in writing on the landlord or its solicitors, such notice to expire on the 3rd anniversary of the term commencement date, determine this lease, and upon expiry of such notice, this lease shall cease and determine and have no further effect. The notice was served in these terms. Pursuant to clause 7.13 of the lease, we as tenant hereby give you notice to determine the lease on 12th January 1995. Unfortunately, the 3rd anniversary of the term was not 12th January 1995, but 13th January 1995. Well, there is a way of saving oneself, and that is what we do in the case of a notice to quit. And a quote from Sidebotham and Holland: "The plaintiff has only himself to blame for the difficulties he is in this case. Had he added the words, which are very ordinarily inserted in a notice to quit, or at the expiration of the year of your tenancy, which shall expire next after the end of 1/2 year from the service of this notice, and which are inserted to avoid such a point as that now taken, all would have been in order, but the words are not here." So using that analogy, Lord Gough, who was dissenting in Mannai, said, "Furthermore, it is also well settled that, if the person giving the notice specifies the actual date, but out of caution also specifies, in the alternative, the end of the period at which the notice is required under the clause to take effect, the alternative so given will be effective to save the notice if the actual date so given should prove to have been mistaken." Now, for my part, although as a property lawyer, I'm familiar with these words and the safety net that is traditionally used, I do wonder how many lay people actually find it clear when they read a notice that states a particular date, but then also states another date which is at the end of a period next. So let's look at the course of Mannai as it made its way up the courts. At first instance, His Honour Judge Rich, sitting as a judge of the High Court, he held that the notices were good. He said that they took effect at the moment of time, which was both the last moment of 12th of January and the first of 13th January, so that the lease is determined on the 13th of January. In effect, this is the scintilla temporis argument, that there is a moment of time which is neither one day nor the other when the two merge or intersect. The Court of Appeal disagreed. It was held that a notice stated to take effect on 12th of January could not operate to determine the lease on the 13th January. The notices were bad. In the House of Lords, it was held that a reasonable recipient with knowledge of the terms of the leases and of the third anniversary date would have been left in no doubt that the tenant wished to determine the leases on the 13th of January, but had wrongly described it as 12th January. So we looked at the example of the Royal Festival Hall and the concert, because that is Lord Hoffman relating notices and the concept of the reasonable recipient to common sense. So here was another example that he gave, quoting from earlier authority, which again, I find troubling as a matter of common sense and interpretation. The old rule, if the words of the document were capable of referring unambiguously to a person or thing, no extrinsic evidence was admissible to show that the author was using them to refer to something or someone else. He then referred to the case of Fish, Ingham, and Rayner. In that case, a testator left his residuary estate to his niece Eliza. But in fact, he had no niece, Eliza, but his wife had an illegitimate grandniece called Eliza, to whom the evidence of their relationship showed that he must have intended to refer, and also, as it happened, a legitimate grandniece called Eliza. Court of Appeal held that the estate went to the legitimate grandniece and that the evidence of the relationship between the testator and the illegitimate grandniece was inadmissible. Lord Justice Lindley said, where the person most nearly answering the description is the legitimate grandniece of the testator's wife, no evidence can be admitted to prove that her illegitimate grandniece was intended. Now, the difficulty I have with this case is that there was no niece Eliza, whether legitimate or illegitimate. There simply was no niece Eliza. There was a grandniece, but that's not the same thing. It was said in that case, on the other hand, if there was no one to whom the description accurately applied, there was said to be a latent ambiguity and evidence of the background facts which showed what the testator must have meant, notwithstanding that he had used the wrong words, was admitted. So again, you might wish to read this passage. You can get these webinar notes, which will be available shortly after this broadcast. It's worth reading, because I wonder whether you will take the view that this is not a straightforward, common sense answer that everyone would answer in the same way. So what principles do we derive from Mannai? Well, perhaps the first principle is that we should try and get our notices right, so that we're not then thrown back on hoping that we will get some rescue from the concept of what the reasonable recipient would have thought when things go wrong. But Lord Steen put it this way. He said the reasonable recipient would not have been perplexed in any way by the minor error in the notices. The notices would have achieved their intended purpose. So what about conditional break clauses? And here we may have some traps for the unwary. Let's look at the case of Marks and Spencer plc and BNP Paribas Securities Services Trust Co. This case concerned the question of when a break clause is exercised, is there a term to be implied in the lease that there should be a repayment of rent. So on the facts of this case, rent was payable quarterly in advance on the usual quarter days. The tenant's break notice could be exercised, but only if there were no arrears of rent and a break premium of 1 year's rent was paid. Tenant paid the rent in full for the quarter starting 25th December 2011, ending 24th March 2012, and paid the break premium, which was a condition. Tenant then asked for repayment of rent from the period of 25th January to the 24th of March 2012. That's because although the rent had to be paid in advance, the lease actually came to an end on the break on the 25th of January. Landlord refuses to make repayment. So tenant brings proceedings for recovery of rent, car parking fee, insurance and service charges for the post-termination period. At first instance, a term was held to be implied into the lease to the effect that the tenant was entitled to repayment of those sums. The Court of Appeal and the Supreme Court disagreed. So what was their reasoning? Well, implied terms are there, can be brought in where it's for necessity for business efficacy and obviousness. And the Supreme Court considered carefully Belize and warned that it did not relax the traditional and highly restrictive approach to the implication of terms. So there were factors in favour of an implied term. There were factors against the implied term. Now, this is a case which was decided by Mr. Justice Morgan at first instance, and there cannot be any greater landlord and tenant judge to consider such a case, but a conclusion that the Court of Appeal and Supreme Court disagreed with. So in favour of the implied term, well, the payment of rent in advance is referable to a tenant's use and enjoyment. And so there was real force in the argument that if the landlord could retain the rent that had been paid in advance, that would be unfairly prejudicial to the tenant. And at the time of grant, it would not be known by the parties whether or not the break would be exercised. And so that was a factor that suggested that the rent might be recoverable. But against such an implied term, this was a document that was negotiated between extremely experienced parties with expert solicitors, and there's an established legal background that a lease is entered into, which includes that rent is not apportionable in time in common law. To some extent, that is affected by the Apportionment Act 1870 in relation to rent paid in arrears, but not in relation to rent paid in advance. And so the outcome is that, save in a very clear case, no such term would be implied, and the tenant failed in the claim, save in relation to service charge, because service charges are recognised as matters that can be and are often apportioned.
Let's go on to consider one key point that often arises when it comes to engaging break clauses. It's quite usual to include a requirement that as a precondition of engaging the break clause, the demised premises has to be vacant when they are surrendered back to the landlord. Quite often, there can be arguments about whether or not they are indeed vacant. And there have been a number of cases about this, which explores the meaning of what is vacant possession. Mr. Justice Lewison's decision in the Expeditors case has been one of the more important decisions in this field. He took the Court of Appeal decision in Cumberland Consolidated Holdings Limited in Ireland and interpreted what the Master of Rolls, Lord Green, said in that case. Cumberland Consolidated Holdings was in many ways a more extreme case. There was a cellar as part of a property that had been sold, and in that cellar were several cement bags, some of which had solidified. And the cost of actually removing these cement bags came to around 8% of the total cost of sale of the property. And the Master of Rolls effectively advanced two tests when it came to vacant possession. The first one, a more straightforward factual test as to whether or not that you had left anything behind, such as chattels or even people or employees. And if you had, then you simply hadn't surrendered up vacant possession. And Mr. Justice Lewison said that we're considering that from the perspective of the tenant or vendor actually leaving the property. Are you continuing to claim a right to use the premises for your own purposes by using it as a place of deposit for your own goods? But the second test, and the Master of the Rolls, Lord Green, decided it on, he said was equally valid. And that was whether or not these chattels were in any way an impediment to the enjoyment of the premises by the incoming purchaser, or in this case, the landlord taking back possession. And Ms. Justice Lewison said you have to consider this from their perspective. Does he or she suffer an impediment caused by these goods that substantially prevents or interferes with the enjoyment of his or her right possession of a substantial part of property? These decisions were then considered by the Court of Appeal in Ibrand Estates against NYK Logistics. And there, Mr. Justice Lewison's decision in the expediters case was very much approved. A very defendant tenant asserted it had terminated the lease by exercising a right under the break clause. Part of the problem was there was also a condition that the property had to be surrendered up in good condition as well, and the tenant was very keen we would not pay any dilapidations. So it said it would remain in possession, or some of its personnel remain in the premises in order to make good, but the landlord remained silent on the point. The defendant offered to vacate the premises, although in fact it never returned the keys, and it instructed workmen to carry out these repairs and its redecorating obligations after the relevant date for vacant possession. So when the landlord came to visit the premises in the new year, the tenant still had a security guard on the site, there was an employee sweeping up, and there were a few small chattels there. The defendant said, however, it would easily have complied with any instruction to stop work and leave, and that was therefore enough to establish vacant possession. And both at first instance and in the Court of Appeal, this approach was strongly disagreed with. You have to give up vacant possession. It isn't simply about being in a position to give up vacant possession. The property has to be empty of people, and the purchaser has to be able to assume and enjoy immediate and exclusive possession, occupation, and control of it. It also has to be empty of chattels. Although, again, they referred back to Lord Green's test in the Cumberland Consolidated Holdings case, and Mr. Justice Lewison's comments in expediters. The obligation in this respect is likely to be breached only if any chattels left in the property substantially prevent or interfere with the enjoyment of a right possession of a substantial part of the property. Well, that's fine. But we then come on to question the position when it comes to issues such as what is a chattel? And what is throwing up vacant possession? We have such items such as partitions left in the property. And that was the point for His Honour Judge Safran, sitting as a judge of a High Court in the Riverside Park and NHS Property Services case. It's an important decision because so many commercial premises now are let often as shells, and the tenant is permitted to install partitioning so as to make better use of the premises. And there the question will be whether these partitions remain chattels in which case they wouldn't fulfill a test as to vacant possession, or whether they are in fact incorporated as part of the demise, either as tenants' fixtures or perhaps even as landlords' fixtures, depending on the terms of the lease, in which case leaving behind these partitions would mean that you could surrender up vacant possession. And so the judge had to go into the method of construction of the partitions themselves to decide whether or not they remained as chattels or whether they had in fact become part of the building. I considered that these were standard demountable partitions, and looking at the detail in the case report, these partitions were not installed in such a way that went into the structural parts of the building. They were simply screwed into place and simply went into the floor and into the ceiling. Secondly, looking at the objective purpose of these partitions, it was simply to benefit the tenant. That was by creating smaller offices. There was no question of this benefiting the land itself. It's simply to allow a tenant to better enjoy the premises. And so it's held that by failing to remove these partitions, the tenant had failed to surrender up vacant possession. But the case does show that often these cases can turn on a knife edge. If these partitions had been installed and had been fitted into the structural parts of the building, the case might very well have turned the other way. And so when it comes to strict compliance, very often, as we've seen in these cases, it isn't necessarily clear what you actually have to do in order to comply. This is slightly different to the more recent case of Goldman Sachs International Procession House, where the terms of the lease itself were unclear. And so it wasn't at all certain what the tenant had to do in order to comply with a precondition for surrendering up vacant possession. The break clause said that this exercising the clause was subject to the tenant being able to yield up the premises with vacant possession as provided in clause 23.2. And at first blush, it looks clear. You have to surrender up vacant possession complying with clause 23.2. But clause 23.2 itself says that on expiration of such notice, the term shall cease and determine, brackets, and the tenant shall yield up the premises in accordance with clause 11 and with full vacant possession. So clause 23.2 referred back to clause 11, and clause 11 was a reinstatement obligation. And in order to comply with reinstatement obligation, there were a series of far looser tests as to, for example, the landlord's reasonable satisfaction as to whether or not had been yielded up fully reinstated. And so there are arguments going both ways in the High Court. And it isn't at all clear whether 23.2 meant that you also had to comply with clause 11 in order to satisfy the break clause. So it went on a partate claim to the High Court, and it was held that both parties' interpretations of the clause were possible. However, the natural and ordinary meaning of the break clause was simply the tenant had to yield up with vacant possession. Because these break clauses have very draconian implications. If you do satisfy them, the one party unilaterally can end the tenancy before the expiry of its term. But if you don't comply with it, then you have to remain paying rent under the lease. And so the judge said it was incumbent on a landlord to make the extent of any such condition very clear indeed, certainly not by reference to a looser test. This, again, is a case which turns on a knife edge, and it can be quite usual to see leases containing obligations as to repair and as to reinstatement of the premises, for example, shall be in full repair. And if they're not, of course, as you've seen, then there are arguments as to whether or not the break clause has been properly validated or applied. And quite often landlords and tenants enter into settlement agreements so as to avoid that ambiguity. But again, this is a potential snare for the unwary. When drafting a lease, you have to be absolutely clear how a break clause can be activated. Not all leases are contracted out of a Landlord and Tenant Act 1954 and the protections given under Part 2. And this provision or this statute creates its own particular set of snares for the unwary. Because a break notice simply determines the contractual term, whereas a tenancy protected by Part 2 of the Landlord and Tenant Act 1954 can only be ended by a way specified in that Act. And generally, this would be by way of a landlord serving a Section 25 notice. And a party therefore has to end the protection given by Part 2 of the Act. This isn't generally a problem when a tenant serves break notice, and these can quite often operate under Section 24(2) or even Section 27. It's more difficult, however, when a landlord seeks to exercise a break clause by serving a break notice, because at the same time they also have to engage Section 25 of the 1954 Act. Now, the Court of Appeal considered that a single notice can engage both Section 25 and contractual terms by doing double duty. And that was the decision of Goldman Manufacturing Company Limited against Clifton. And indeed, when we look at Aberdeen Steakhouses Group of Crown Estate Commissioners, that was a case where the Section 25 notice had to be construed by reference to the cover letter itself, and it made it clear that the notice was served both under the Act and under the break clause of the lease, so as to enable the landlords to redevelop the building with adjoining buildings. But before we move away from this point, the 1954 Act does throw up a number of different problems. So, for example, the landlord who is capable of serving break notice might very well be different to the landlord who is capable of serving the notice under Section 25, or the competent landlord as styled by the 1954 Act. Sometimes, occasionally, a break notice can allow for termination of only part of property, but a Section 25 notice has to be served for the whole of a property or a holding. It's also noteworthy that the time provisions for Section 25, not less than 6 and not more than 12 months, can be different to the time provisions for a break clause. And often landlords are best advised to serve two different notices. Just before we move on to the next slide, I've been asked on questions on the Zoom questions and answers in the Goldman Sachs case, was there a condition to give up vacant possession on the break date, such that if there was no vacant possession, there was no break, as opposed to just a breach of covenant or damages claim? And this indeed was one of the arguments that was raised by the landlord, but I'm not sure how strongly it was advanced. Because of the way the clause had been drafted, there was an ambiguity as to whether or not when you triggered the break clause, you had to have vacant possession both when you serve a notice and on the date you surrendered up possession. And the High Court held in that case that it would be a very strange interpretation for the tenant to have to be surrendering up vacant possession during the period of until the break notice actually expired, which from my recollection was around 6 months, and for during the last part of the term for it to still be in vacant possession would be a very strange way of interpreting that clause, because effectively the property would be useless for that last 6 months. But yes, it was a point that was raised in the High Court, and again arises out of the ambiguity that is inherent in the way that this was drafted. So if in doubt, make it absolutely clear that vacant possession, if you're drafting this, that vacant possession should be on the date that you surrender up the premises, and it shouldn't instead be on the date that you are serving the notice. Whereas often when you do serve a notice, as we saw in the BNP and Marks and Spencer's case, you have to make sure that all your rent is paid up to date. So again, there can be problems with the drafting and with compliance of these particular provisions. Well, thank you very much for your question on that. Just turning back then to the 1954 Act. Quite often, tenants or landlords indeed, when it comes to a lease renewal case under the 1954 Act, will want to insert a break clause. And I have seen as the demand for market rent and for retail premises in particular has softened, both tenants often are quite keen to insert break clauses, landlords are quite keen to resist them. But landlords are often quite keen to insert break clauses if they can't quite meet ground F, which is a redevelopment provision, or they can't quite meet ground G, which is intended to occupy it for their own business or to live in it now, but they can see a time when planning might become easier, or they're in a better position to carry out redevelopment in the future, and in which case they'll want to have the ability to serve a break notice before the end of the term. And this is governed by Section 35 of the Landlord and Tenant Act 1954, which effectively throws it back onto the court. The court shall have regard to the terms of the current tenancy and to all relevant circumstances. And the somewhat loose and colloquial test that's being applied is redevelopment on the cards? So in effect, is there reasonable prospects of the landlord in a ground F or quasi ground F case being able to show in the future that it will redevelop? And it isn't necessarily this landlord, it could be a landlord that the current landlord sells on to. And we often go back, if we're representing landlords, to the case of Adams and Green, where it's made clear that the policy of the Act is not to prevent redevelopment of commercial premises. And this case went to Mr. Justice Lewison in Davies of London Wine Merchants Limited against City of London Corporation. Where it was made clear, this is often a question of discretion for the first instance judge if you're dealing with a matter going on to appeal. The law is slightly looser and less clear when it comes to a tenant break clause case. But one of the points that tenants are often advised to do is to not simply refer to the general state of the market, but to refer back to the actual premises themselves as to why in the future a break clause should be inserted, and they may wish to determine, rather than more by reference to more general factors such as it's not quite clear what High Street will do in the next 6 months or 12 months or so. So break clauses, when it comes to renewal cases inside the Act, can often throw up a number of issues, and there are a number of cases which can cause problems, particularly if a landlord has just missed out on making out a ground F case. Now I'd like to hand back to Damian and the registration gap.
Well, let us suppose that you have passed with flying colours and you are aware of each and every one of the excellent points that David has made and the points that I've made. Can it still go wrong? Yes, it can. The registration gap and a sanitary tale arises from the case of Sackville UK Property Select and Robertson Taylor Insurance Brokers. So in this case, the facts were that the claimant had demised office premises in central London, term of 10 years. Second defendant acquired the business and shares of the first defendant, and then the first defendant was wholly owned subsidiary within the same group. With the written consent of the claimants, that was required under the lease, D1 assigns by lease to D2. It's the same solicitor who is acting for both defendants because he's acting for the group of companies, and he proceeds on the incorrect basis that the lease was not an interest required to be registered at land registry. Going back some years, obviously in his mind, he is thinking 10 years is not a registrable lease, only 21, but of course that changed by the 2002 Act. And so the deed of assignment that is used is appropriate for an unregistered interest, whereas of course form TR1 should have been used as registered land. And so he serves notices to break, but in the name of D2. Problem is, D2 was not the registered proprietor of the lease until after service. The claimants brought Part 8 proceedings, sought summary judgment. They argued that D2 could not serve such a notice because it was not at the time the registered proprietor. Defendant's argument was that claimants obviously realized that this was a mistake. They knew full well that the defendant's solicitor had authority to serve the notice in respect of whichever party was suitable. They knew of the arrangement, they knew of the takeover, they knew that this was a restructuring of the defendant's businesses. So the defendants argued that the notice was, in all the circumstances, valid and effective. They also argued that a reasonable recipient in the position of the claimants could have been in no doubt that the notice was intended to be served on behalf of the person who was the tenant, and that's the Mannai argument. The claimant's argument against that was that the second defendant was only an equitable assignee, and Section 27 of the Land Registration Act was conclusive. A disposition of a registered estate did not operate at law until the disposition was completed by registration. Now, the Mannai point was rejected, but it may be uncharitable but true to say that the timing of the landlord's notification to the tenant was no coincidence. They waited until it was too late for the tenant to serve a good notice, or i.e. the assignor who was still legally the tenant. So they only brought the point up once it was too late. This Part 8 claim, in effect, became a declaration that was defended before negligence proceedings were brought against the unfortunate solicitor who had made that simple error. So what we see from this, the registration gap is a problem, because we cannot, until electronic conveyancing is in force, be sure of how long Land Registry will take to register a new owner as the registered proprietor. But there is one possible way around it. If one is negotiating contracts, it may be possible to persuade the other party to have additional clauses in a sale contract to appoint the buyer of the interest as the seller's agent during the registration gap. And that would allow the other party to serve notice and not be caught by the registration gap problem.
That's the end of our webinar on some of the problems and issues created by break clauses and break notices. This is part of a series of webinars that's presented by 39 Essex Chambers on property, construction and related areas. And in fact, forms part of a series of webinars on commercial property and real property. And you can find more details of forthcoming webinars and seminars, and also recordings and slides about ones that have already been given on the Chamber's website, and the address for that is on your screen. This recording of this webinar and the slides should be available shortly after this conclusion of today's session. Also like to note that the latest updates on COVID-19 related issues are collated on the 39 Essex Chambers website in its own dedicated section. Again, the link for that is on this slide.
Well, thank you very much for attending, and I do hope you'll tune into our next webinar, and I hope that you will have found this topic interesting, because we are seeing it as one of enormous importance at the moment, as businesses have to plan for the future and are considering their economic welfare at the moment. Hope to see you at the next one.